online, to my knowledge, that you still can't do that online. So,
Under a general index.
but on the other, well, it wouldn't be in the normal court records unless they go to court to get dissolved. If they do this in a, the fact that they become a domestic partnership is not a court record. It's a public record in the Secretary of State's office, but just like wedding marriages are a public record in the California Department of Health, or in the Los Angeles County Department of, I think it's Health Services, where you can go and find the fact that somebody's married, but it's an inconvenient thing to do. So if you're asking that question from the standpoint of what should I do as a listing agent or as a selling agent, the answer is, go forth and list and sell properties, and guide your clients into doing what they have to do. When they get papers from escrow to fill out a statement of information, they're supposed to be filling them out accurately. And if they do, great. If they don't, none of that information ought to be coming from you. And so, yes, sir. Yes, sir.
I was going to ask you, one thing I've seen over the years, which I've been in real estate many years, where there's a conflict, they fill out a disclosure statement, and also the title company says the square footage on the property. And you go pull permits on the property, and there's a big conflict with what is represented. Now, is there any responsibility on either selling agents or listing agents do an investigation by pulling permits on listings?
The rules say no. Did everybody hear the question? So the rules say no. The rules say that when you conduct a careful visual inspection of properties to satisfy your obligations that lead to you filling out your portion of the transfer disclosure statement, but it's more than that. But that's the place you would fill it out, or the agent's visual inspection disclosure on a transaction that's exempt from a transfer disclosure statement. You use the AVID form. The rules say that you're obligated to conduct a careful visual inspection of accessible areas of the property that is offered for sale, which means the house. If it's a condominium, the rules say that means the unit that is offered for sale, not common areas, not permits, not public records. But if you start down the path of going and getting public records, you're obligated to do that correctly and completely. You can't just sort of do that and sort of not do that. You're not obligated to go do that.
Because a lot of times I notice if it isn't disclosed, they start suing you and say, you should have pulled the permits and stuff like that. I mean, I've been involved in that.
Yes, people can say that. And it kind of depends. If you happen to know that this is a room addition, you may want to deal with that fact. If you're familiar with this particular model of home and you know that something was added, you may want to disclose the fact that it's a room addition, or if you see that something jumps out at you as something that doesn't comply with a code requirement. If you happen to know it, you know what the code requirement is, then you have to disclose that. I want to mention, speaking of that, by the way, in the purchase agreement is something called the Megan's Law disclosure. It's a mandatory item that it be in the purchase agreement or in a separate disclosure. So it's in there because the law says that you have to tell buyers the fact that this information is available. And the information is about the fact that there is a registered sex offender database, federal and a separate one at the state of California. There's a website that is accessible that covers all of the states and Puerto Rico and a couple of other U.S. possessions, and there's one that's limited to the state of California that your clients can check by zip code or by name whether there's a registered sex offender living nearby. You are not obligated to go check out that information. Your clients can do that, and if you have actual knowledge, if for whatever reason you do check it out, then you now have actual knowledge of the fact that somebody is living across the hallway as a registered sex offender. That, of course, would be a material fact to most buyers, particularly if they've got kids. but you're not obligated to check to determine that information. You're obligated to use a purchase agreement that discloses to the buyer or the seller the fact that this information is readily available at the websites.
Is there a statute of limitations for the seller in the event if there's a non-disclosure of an unrecorded lease agreement for the buyer to sue him? A statute of limitations of non-disclosure of a lease agreement, washer dryer lease agreement.
Oh, washer dryer, okay. And he knew about this, the seller knew about it. Well, first of all, on any kind of claim, any legal claim, there's a different statute of limitations depending on what the buyer or what the plaintiff sues you for, exactly what they say you did wrong. Negligence has one statute of limitation. Breach of contract has another. Breach of statute has another, or it depends on which statute it is. Fraud has another. So yeah, there's a statute of limitations that applies to every single kind of claim, and the buyer lawyer is going to typically sue for as many different kinds of legal claims as there are. The ones that I mentioned, at least, and then some. So the best I can say for this is, if you are a claimant, if you're a buyer and you believe that the seller didn't disclose something to you, don't wait. You know, so some things just in life need to be handled immediately. If you're the claimant, you file immediately, and if you're the defendant or seller, then you use the fact that the buyer waited a long time as a defense. It's not going to be successful against fraud, but that depends on whether it was really fraud, or I forgot, or I didn't know, or there really isn't a lease. You know, they say there's a lease. Depends on all the facts. Have I successfully not answered your question?
So many variables there.
It's a lot of variables. Yes, sir. Hi, Bill.
To clarify your answer regarding liquidated damages, does liquidated damages mean any breach gives the seller the entire amount of liquidated damages, or does the liquidated damages cap the buyer's exposure on the piece of
All right. The question is, the liquidated damages clause in the purchase agreement, does that just cap how much the buyer could possibly be liable for, or does the seller automatically get that amount of money? First of all, the seller only gets money under the liquidated damages clause if the buyer breaches the contract, which basically means the buyers removed their contingencies and now they fail to go forward with the transaction. Or maybe they've gone past the date that they're supposed to remove contingencies, and fail to do that. It's not, the purchase agreement does not say what I just said. Purchase agreement says that the buyer's contingencies continue even though you're past the 17 days or you're past whatever number of days you've filled in. The buyer's right to disapprove or to cancel continues on until either the buyer removes contingencies or until the seller gives a notice to the buyer to perform and then cancels. So I understand the purchase agreement says that. I don't think it's perfectly safe, however, for a buyer to wait, go past the buyer 17 days, and then at day 27 or 37 say, I've decided not to go forward. Because then the seller's exposed to, the buyer's exposed to a claim by the seller that the buyer was acting in bad faith, which is a different kind of claim. So if we're talking about, if that question means during the 17 days or whatever number of days you have in there, if the buyer hasn't removed contingencies, there is no breach by the fact that the buyer decides not to go forward. If the buyer removes contingencies, then on paper what it means is the seller is entitled to the liquidated damages amount, the whole liquidated damages amount, because the buyer has an unconditional obligation to go forward with the sale, failed to do that. Now, that's fine, and that's how it should go, but escrow is not going to release the money anyway. The purchase agreement and California law say that the escrow holder is going to continue holding on to the money until either the buyer and seller give a mutual, consistent instruction to the escrow holder on what to do with the money, how to cancel the sale, or the parties go to an arbitration or lawsuit. And then the arbitrator or judge orders the disposition of the liquidated damages. So if you have a valid liquidated damages clause, it caps how much the buyer can be liable for, meaning if you have say it's a $300,000 purchase, and say you have a 3% deposit, which is $9,000, it means that the seller won't presumably be able to get more than $9,000, even if they've suffered $25,000 in damage for the fact that the property's off the market for a long period of time, or whatever they want to claim their damages are. The liquidated damages clause, whatever you filled in there, and if it's residential, the maximum amount that can be subject to a pre-agreed liquidated damages clause is 3% of the purchase price. If it's non-residential, the 3% does not apply, and if you have a deposit that's more than 3%, the liquidated damages clause applies to only 3% of that. Second item is that if you have a purchase agreement where you have an increased deposit, the liquidated damages clause in the purchase agreement doesn't apply to the increase unless you get a separate signed or initialed liquidated damages clause at the time the increased deposit is made. There's a form for that, and it's called RFID, the CAR form, Receipt for Increased Deposit and Liquidated Damages. Even though the parties have agreed in the purchase agreement that liquidated damages will apply to the original deposit and a future deposit, that's not the law, and somebody's going to be real unhappy when they find out that even if the buyer came in with the additional deposit that they were supposed to when, let's say, when the interior inspections are done, or whatever event is shown in the purchase agreement as triggering a new deposit or an additional deposit, the California statute is really very clear. You have to have a separate signed or initialed liquidated damages clause at the time of the increase.
Real quick, now, if the seller, in commercial, not in residential, the seller wants to give the agent the percentage of commission of liquidated damages, I'm talking about $25,000 liquidated damages, which was released by the buyer. Are we opening ourselves up to a problem if the seller wants to, through the brokerage, it's not just here with the envelope? I mean, are we in trouble, or do we have to have them sign something that if they want to give us our 6% or 8% of our stated commission?
Well, I think the purchase, certainly the listing says that, right? It says that that I, seller, will pay you blank percent on the earlier of either the close of escrow, or if the seller breaches, then upon the seller's breach, or if the buyer breaches, then if and when the seller gets damages from the buyer, either by way of a lawsuit or liquidated damages, in which event the broker gets an amount equal to half of the forfeited deposit, or half of the amount that the seller gets, not to exceed the whole amount that the broker should have gotten in the first place. So I think that's, if you're on a listing, it's already in the listing agreement like that.
Okay, but escrow then would just simply show that disbursement when they gave it to the seller?
Well, yeah, I mean, escrow's still going to require that the seller give a new instruction to actually give you the money, at the time of a breach.
We can go over that if you get a personal situation.
Yeah, happy to. I will
And
be
Steve's
here.
going to be around here for a couple minutes afterwards if you have something specific. But let's give him a big hand. Appreciate it.
Thank you very much.